Good evening. In the immortal words of what's that guy's name? Fuck it, we'll do it live. Anyway, fuck it, we'll do it live. Uh my computer's doing like downloads and shit, so I don't know what's going on. Um anyway, we're going to go ahead and we're going to go over document 35 and 36 in DeCastro versus Wagner. This is going to be pretty fast, easy, and fun. Document 35 is now comes defendants Pam Wagner, Brad Spoljaric, blah, 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 by and through counsel, and hereby move the court to grant them leave via notation order to manually file a flash drive containing the full unredacted audio and video of plaintiff's arrest, which she recorded. The video and audio can't be filed through the court CMECF system. And guess what, kids? That's it. That's all you get because it was granted. It was granted. It was granted. So what are you going to do? It was granted. Chile never got to respond to it. He didn't respond to it. I don't know if he's going to ever respond to it. I'm sure in about another 3 to 5 days, he's going to figure out that he should have responded to it, and he's going to go ahead and respond to it. But he didn't, and so here we are. So there you go. The next thing we're going to look at is we're going to look at this, which I'm going to make bigger. That's what she said. This, since they got their flash drive filed with the recorded arrest, with Chili's recorded arrest that he recorded, which is, you know, one thing I've always cautioned these auditors on is a lot of times you are filming yourself. I said dockets 35 and 35. Huh, I'm an idiot. A lot of times you are filming yourself committing a crime. And that's usually not a good thing, to document yourself committing a crime. I remember, who's that one gal? What in the hell's going on here? There was that one gal, something in Fort Worth. Anyway, she literally like trespassed in some trailers and stuff that she wasn't allowed to be in, and she filmed herself doing it. It's stupid. The gal that Freeman put up, who was wandering through restricted areas of school bus mechanics areas, just blatantly filming herself trespassing. Like, what are you doing? Everybody stop and think about what you're filming. Chili, in order to make a few bucks on a live stream, filmed himself committing a crime. So let's go through it. It's well written, and I don't even know, am I even live? Am I real? What the hell's going on? What the fuck is going on? Like, my desktop is locked up. Mom! All right. Well, I don't know what to do here, so I just heard myself scream. My shit's all jacked. I don't even know what to do. Well, Well, hello. One quick stream or computer restart later, and for some reason, I am still streaming. That's kind of weird. That's kind of weird, kids. All right. So we're going to do this. And we're going to do this. I hope I'm still live. Still no toothbrush and still puby face, but I'm ready for it. You ready for it? Are you really ready for it? Am I frozen now? Jesus Christ. Christ on a cracker. Yes, this is my best stream ever. This is the kind of quality production values that you can expect to get from me. What were you doing with the light off, huh? Well, light off and pants off. All right, let's do this. Let's do this. So this is so they got the flash drive filed with the video evidence on it. Now here they go with their reply in support of their motion, I guess. So there's been a motion, Chile filed in opposition, and now there's a reply. Now come defendants, Pam Wagner, Brad, yada, yada, in the reply in support of their motion for judgment on the pleadings and state as follows. Plaintiff has not satisfied his burden to overcome the Ironton defendant's motion for judgment on the pleadings. Plaintiff can prove no set of facts in support of his claims that would entitle him to relief. Plaintiff sets forth 4 causes for relief, namely alleged violations of the 4th Amendment, 14th Amendment, due process, 1st Amendment, and a Monell claim. As an initial matter, plaintiff's response in opposition to defendant's motion for judgment on the pleadings, response, it's an opposition, you fuckwits, has ventured well beyond the bounds of the pleadings. A motion for judgment on the pleadings tests the sufficiency of the allegations contained in the complaint and answer. Plaintiff does not have carte blanche to add allegations and factual assertions. Furthermore, as outlined infra, plaintiff's piecemeal adoption of facts and generally disingenuous, self-serving adaptation of the facts should be taken into consideration by this court. A motion for judgment on the pleadings, your pleadings are kind of the controlling thing, right? The pleadings, what the plaintiff asks for are the bounds of what he can get. And the allegations that he makes in those pleadings have to be sufficient that, if true, he would be entitled for relief. Now, what Chile's doing, I see a lot. I see it from attorneys as well. They realize that they don't have all the allegations they need in their pleadings. They don't want to get the motion for summary judgment granted, and so they add stuff. I've seen attorneys, I've seen pro se litigants try to add stuff to appeals, which are just purely on the grounds of, oh look, on her date, watching a stream, on her date. So appeals are based purely on the evidence that was presented in the trial court. And yes, I do. However, they'll still try to add stuff in, and it doesn't work. You go in an appeal, you go based on the lower court's record. In a motion for judgment on the pleadings, you go on the pleadings. As such, and things that are referenced in the pleadings. So, for example, the video that Chile made is referenced in the pleadings. So there you go. As such, the Ironton defendants have filed a motion for leave to manually file, which, if granted, will be comprised of a flash drive containing a true and accurate copy of the full video recorded by plaintiff of his arrest video. Plaintiff put the video at issue by attaching it to his amended complaint. And then we have a little footnote. Plaintiff failed to serve the Ironton defendants with a copy of the video he filed, despite requests to do so. The Ironton defendants were forced to obtain a copy from the court at additional time and expense to them. That's just them being a little salty about it. However, he intentionally cut out portions of the video. Chile? Spoliating evidence? Not our Chile. Chile would never spoliate evidence. Seeing, as plaintiff argues, a theory of selective enforcement. Seeing as? seeing as plaintiff argues a theory of selective enforcement, it is integral that the court have access to all of the facts surrounding plaintiff's arrest. Emphasis added. No shit. No shit. Did you know? I don't know if anybody else caught it before they pointed it out that it was an emphasis added. Did you notice that they had underlined it? I'm glad that they told us that they had underlined it, because I would not have caught that they had underlined it. Furthermore, the Sixth Circuit allows for the consideration of video evidence at the pleading stage through Federal Rules of Civil Procedure 10C, even when the video was attached to the pleadings by the moving party defendant. See Osbury versus Slusher. Here, plaintiff put the video at issue. Thus, the court should consider the full, unredacted version of the video. And that video makes Chili look terrible. So yes, I think that court would be well within its rights to look at the whole unredacted video. Plaintiff has failed to establish that he was arrested without probable cause. Thus, his Fourth Amendment claim must fail. A warrantless arrest by a law officer is reasonable under the Fourth Amendment where there is probable cause to believe that a criminal offense has been or is being committed. The validity of the arrest does not depend on whether the suspect actually committed the crime. As a result, in order for a wrongful arrest claim to succeed under Section 1983, a plaintiff must prove the police lacked probable cause. Remember, probable cause is ridiculously easy to get. Probable cause just means that there was probably a crime committed and you're probably the one who did it. That's it. Plaintiff has failed to establish that the Ironton defendants did not have probable cause to arrest him for a criminal trespass. Prior to the police arriving, in response to being told that the building closed at 5 p.m. by the building staff, plaintiff replied, "We're not leaving." We're not leaving? I assume that's "we're not leaving." I'm assuming. We're not leaving. We're protesting. And then they cite to the video. The criminal trespass statute in Ohio provides no person without privilege to do so shall knowingly enter or remain on the land or premises of another, the use of which is lawfully restricted to certain persons, purposes, modes, or hours, when the offender knows the offender is in violation of any such restriction or is reckless in that regard, or being on the land or premises of another, negligently fail or refuse to leave upon being notified by signage posted in a conspicuous place, or otherwise being notified to do so by the owner or occupant, or by the agent or servant of either. Here, plaintiff was on explicit notice, which he recorded himself very, very helpfully, from the building staff that the building was closed and he was trespassing at that time. Of further consequence, plaintiff, by his own admission, states that he was not approached by the police until 5:03 p.m. Period. 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 Consequently, plaintiff had effectively already committed criminal trespass and was subject to a lawful arrest. It should also be noted that pursuant to RC blah, 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 it is not a defense to the charge the premises is owned or controlled by a public agency. The Ohio Revised Code defines privilege as an immunity, license, or right conferred by law bestowed by express or implied grant arising out of a status, position, office, or relationship, or growing out of necessity. Plaintiff had no privilege to be on the property. When the police arrived, the very first statement made to plaintiff was, "Cease and desist your orderly conduct or you will be arrested. Vacate now or you'll be arrested." In response, plaintiff stood still instead of turning around and exiting. In plaintiff's response, he asserts that when this happened, he did not feel free to walk away from Wagner or leave the building, and plaintiff was effectively seized at that moment. Plaintiff's manipulation of the facts to address the glaring issues in his pleadings should be afforded no consideration. More specifically, and as an initial matter, plaintiff alleges in his amended complaint that he was arrested by Spoljaric, Blankenship, McKnight, and Fouch, not Wagner. So the issue there is that he says that he didn't feel free to walk away from Wagner and he was seized at that moment, which means that Wagner would be the person who arrested him. But then he alleges that it wasn't Wagner, it was other people who arrested him. Even further, plaintiff's response contradicts his statement that Pam Wagner had effectively seized and arrested him. You know, that's a real issue. it takes quite a bit more intelligence to lie than it takes to tell the truth. Because when you're lying, when you're a liar McLiar pants who lies a lot, you need to remember all the lies you've told. And you need to be able to quickly manipulate each lie so that it is capable of being worked into a whole, so that you don't have little facts that don't work in and that stick out glaring. So Chili is not equipped mentally to be the kind of liar that he thinks he is. And another real hard fact that Chili's going to have to learn is that when you write things down and you sign them under penalty of perjury, they are forever. You submit it to the court and it's forever. And those other attorneys are not going to be stupid. Unlike Chili, they are going to have had enough intellectual brain power not only to go through college, which Chili wasn't able to do, and go through law school, which Chili never had the opportunity to do, but they were also smart enough to take and pass the bar exam. So these are going to be reasonably intelligent people who are going to be looking at these documents, going through them with a fine-tooth comb. Sometimes multiple attorneys will be looking at them and going through them. And they're going to be remembering things and picking up inconsistencies. And it's the little things sometimes that start sticking out, And once you start picking at the threads, lies unravel really quick. A few paragraphs later, plaintiff states he did not realize he was being arrested until he was being escorted from the lobby when Pam Wagner was no longer present or in the video. This is even further contradictory to his express understanding of the situation, as plaintiff stated, they're arresting me before being escorted out of the lobby. Ultimately, even if the court considers or adopts any of plaintiff's theories, it is of no consequence as to whether he was lawfully arrested. And we have a footnote. It should be noted that plaintiff failed to appear for his criminal case and a warrant has been issued for his arrest. On a Rule 12b-6 or 12c motion, the court may take judicial notice of other court proceedings without converting the motion into one for summary judgment. Oopsie doodles. Plaintiff further contends. So, by the way, now why would the court consider the fact that he failed to appear for his criminal case and the warrant has been issued? Well, he signed something saying that he would appear. He gave his word that he would appear. And yet, he did not appear. What does that mean? That means that you might not want to trust Chili because he's a liar. He is a proverbial liar McLiar pants who lies. And courts, most people, generally speaking, don't like liar McLiar pants who lie. Plaintiff further contends that he was not, quote, given time to leave the building, end quote, and, quote, at no time did plaintiff refuse to leave, end quote. Presumably, plaintiff is referring to the allegations in his amended complaint. Therein, he states that the Ironton defendants, quote, failed to comply with the state of Ohio peaceful protest statutes, policies, and procedures when they encountered plaintiff on 3/29/22. Instead of directing and escorting plaintiff out of the building per these statutes, the defendants chose to make an arrest. Plaintiff's response fails to identify any statute that would permit his conduct because no statute exists. First off, criminal trespass does not require an explicit refusal to leave a property. Rather, it requires, in this instance, knowingly staying on the property, which is lawfully restricted to certain hours. Plaintiff knowingly stayed on the property past when he was privileged to do so. The building staff told him the building was being closed at 5 p.m. At that time, the exit of the building could be observed in the video just a few feet away. Yet plaintiff purposely did not leave, even though he had time to do so. Rather, he lectured those present on how to video police when protesting. I'm going to start my constitutional law scholar classes. Furthermore, plaintiff explicitly stated that the building staff, quote, explicitly stated to the building staff, again, is this we're not leaving, we're protesting, or we're not leaving, we're protesting? This is twice they did it. I don't know. Maybe it's a transcription error. I don't know. Thus, plaintiff's argument that he was not given time to exit the building is disingenuous at best. I just straight call him a liar, but okay. Disingenuous at best. Finally, plaintiff contends that when the officers arrived, at that point, he was willing to exit the building and, quote, did not refuse to leave the premises, end quote. However, his actions dictate otherwise. Plaintiff failed to exit or otherwise head toward the exit after being ordered cease and desist your disorderly conduct or you'll be arrested, vacate now or you'll be arrested. Again, this court need not consider this argument as plaintiff was committing criminal trespass for the 3 minutes prior to the police arriving. And again, all they had to do was have probable cause. And I mean, they don't even have to be able to prove it beyond a reasonable doubt or anything like that, or preponderance of the evidence. All you have to do is have had probable cause. Plaintiff points to State versus Shelton, a 1989 case in support of a 1989 Ohio court case, not a federal case, in support of the notion that the officers should have determined whether plaintiff would peacefully leave. However, Shelton is highly distinguishable in virtually every respect. Of critical importance is that the public lobby at issue in Shelton was open to the public 24 hours a day. Furthermore, the person had been asked to leave earlier in the day and was arrested when she returned later that night. I think Shelton was a police station, if I remember correctly. It was a police station lobby. However, she was not asked to leave before being arrested when she returned. Finally, the deputy admitted that he arrested her because she was a quote nuisance. When contrasted against the facts herein, it is abundantly clear the difference in circumstances. Plaintiff knew the building was closed and was no longer open to the public. He was ordered to leave by both building staff and police officers. He explicitly refused their order and was arrested for criminal trespass, not because he was a, quote, nuisance, end quote. But let's not mince words. He's a fucking nuisance. While plaintiff is correct in pointing out that he lawfully entered the building and that every person has a privilege to enter public buildings, plaintiff's argument that the Ironton defendants revoked his privilege is incorrect. The Ironton defendants did not revoke his privilege. Any privilege plaintiff had was extinguished at 5 p.m. when the building lawfully closed to the public, and he refused to leave and obey the building staff's order to exit the building. As outlined supra just means above, and by the plaintiff's own admission, he knowingly stayed on the property past 5 p.m. and was subject to being lawfully arrested pursuant to criminal trespass. Accordingly, plaintiff has failed to overcome the Ironton defendant's argument regarding plaintiff's Fourth Amendment unlawful arrest claim. They had a lot of words, and I think that's why this is 16 pages long. I would not have added as many words. But I guess they're doing a lot better than Chile does. That's for sure. This is a very adequate pleading so far. Plaintiff has failed to establish that his iPhone was unlawfully searched. As an initial matter, plaintiff's iPhone was seized pursuant to a lawful arrest, as discussed herein. As to plaintiff's claims that the Ironton defendants illegally searched his phone, plaintiff has provided no basis upon which the court should accept this allegation as true. Rather, the Ironton defendants applied for a search warrant to access plaintiff's phone, and the application was denied. If the Ironton defendants were planning to search plaintiff's phone irrespective of the court order, they would not have filed for the warrant in the first place. Thus, this allegation should be disregarded by the court. Well, that was a fairly weak argument. Yeah, I wouldn't have asked permission if I was just going to do it anyway. I mean, I don't know. I've never had kids. But I have been a kid, and I've seen other parents deal with kids, and I know. I remember when I was a kid, My mom got these fudge pops, and they were in the freezer, and I ate a fudge pop when I got home from school. My mom was at work, and then I ate another fudge pop, and I was right about to get a third fudge pop, and I heard my mom pull up, and I went outside. I'm like, Mom, can I have a fudge pop? And she looked at my face, which obviously was covered in fudge, wink, and she's like, I think you've already had one. Oh. I mean, it's just one of those things, Just because you ask for permission doesn't mean that you aren't going to do it if you don't get permission, and it doesn't mean you didn't try to do it anyway while you were waiting to see if you can get permission. So I think the biggest thing here is I don't think that they have on summary judgment they can't really show unequivocally that it wasn't searched. And if it comes down to a question of whether or not the court is going to believe Chili or believe the Arrington defendants, well, that's a question of fact. And that's something that normally has to go to trial. So if this is decided fairly, I don't think that they win on this, because they haven't overcome, like, they haven't been able to show, like, that Chili was that Chili contradicted himself or anything like that. They haven't been able to show that. He made the allegation. If the allegation is true, then he gets to go. And on a motion for summary judgment, the court has to, unless there's some clear contradictory evidence, the court has to assume it's true. So they should lose on this one. And I know people don't like to hear that, but they should lose on that one. Because they're basically making a factual argument. And who's the court going to believe? Well, the court has to accept Chili's allegations as true, if they're fact based, if there's a factual basis for them. Now, they say that the plaintiff provided no basis upon which the court should accept this allegation as true, but I think the court has to. So we'll see. We'll see about that. Maybe the court will come up with something that I don't know. C, plaintiff has failed to support or demonstrate that he is entitled to relief under the First Amendment. The Arrington defendants did not retaliate against plaintiff for exercising his First Amendment rights. Rather, as noted above, he was arrested for trespassing on property after he'd been asked to leave on more than one occasion. Plaintiff's amended complaint alleges that he was retaliated against by the Arrington defendants to prevent him from exercising his First Amendment rights, including to record public officials. More specifically, they kept plaintiff's main recording device from him in order to impede, stop, otherwise deter plaintiff from filming public officials, conducting and recording interviews, and other investigatory filming. To succeed on a First Amendment retaliation claim, plaintiffs must prove the following elements. Number one, he engaged in constitutionally protected conduct. That's where he's going to fail, because he was trespassing. Two, an adverse action was taken against him that would deter a person of ordinary firmness from continuing to engage in that conduct. Yes, but he already failed on number one. And three, the adverse action was motivated, at least in part, by his protected conduct. So again, you don't get there because he was trespassing. Here, plaintiff alleges that the Arrington defendants retaliated against him for exercising his First Amendment rights by arresting him and searching and damaging his phone. Plaintiff's First Amendment claim is deficient for several reasons. First, plaintiff had the burden of showing that the conduct he was engaged in was constitutionally protected. Although the building at issue houses government agents and offices, the amended complaint does not. Why did they capitalize that? Does not plead or allege he was engaged in any protected activity. Rather, plaintiff alleges that he was waiting, quote, for a permit to use one of the rooms for a constitutional teaching session. Oh, Chili. Your words get you every time, buddy. Plaintiff does not indicate that he applied for a permit or was engaged in any other protected activity at the time he was criminally trespassing in the building. Consequently, plaintiff has failed to establish the predicate protected conduct for the Arrington defendants' alleged misconduct. Where the well-pleaded facts do not permit the court to infer more than the mere possibility of misconduct, the complaint has alleged, but it has not shown that the pleader is entitled to relief. As to the alleged adverse action, where the adverse action takes the form of an arrest and subsequent prosecution, the plaintiff must show an absence of probable cause. Here, as is set forth fully above, the Arrington defendants had probable cause for the arrest of for the arrest because plaintiff was criminally trespassing. As to plaintiff's remaining allegations of searching and damaging his phone, these allegations are above and below, respectively. I don't know what that sentence is supposed to mean. To the extent that plaintiff is pleading that he was prevented from recording public officials after his release from custody because the Ironton defendants had seized his iPhone 12, he was the subject of lawful arrest, and the protected conduct complained of occurred ex post facto. So he's saying that the protected conduct complained of occurred after the arrest. An ex post facto law is normally something like where you do something and then they write a law making what you did illegal, and then they arrest you for what you did before the law was written. So it's a weird way of using it. So I'm thinking that what he's saying is they arrested him, and then after the arrest and after he was out on bond or whatever, because of the prior arrest, he now couldn't exercise his First Amendment right, which is, it is a weird kind of thing to argue. There's no precedent that the ability to regain possession of one's property for purpose of recording public officials after a lawful arrest falls within the confines of protected First Amendment conduct. Thus, plaintiff has failed to even establish that the conduct is protected under the First Amendment. Furthermore, as outlined below, the recovery of his property or lack thereof is an issue for state courts. Finally, there is no connection between the activity and the Ironton defendant's motivation for arresting the plaintiff. In fact, Pam Wagner explicitly states, cease and desist your orderly conduct or you will be arrested. Vacate now or you will be arrested. Contrary to plaintiff's belief, there is not a scintilla of evidence that his arrest stemmed from any other activity than his criminal trespass. Well, there is a scintilla of evidence that Pam Wagner stating, cease and desist your disorderly conduct, makes me think that there is some activity other than criminal trespass that might have been pushing towards the arrest. And what would the disorderly conduct be? What would the disorderly conduct be? The words? I don't remember exactly what he did. I don't remember him doing anything like violent or loud or anything like that. He was talking on his phone. I think this is a weak part. I think very strong is that he was not engaged in protected activity. So that's what that I think is going to be the nut that the court is going to end up cracking, is it's not protected activity. Contrary to plaintiff's belief, there's not a scintilla of evidence his arrest stemmed from any other activity than his criminal trespass. Of further consequence, the Ironton defendants allowed plaintiff to continue filming for several minutes after plaintiff seized or after claimant. Of further consequence, the Ironton defendants allowed plaintiff to continue filming for several minutes after plaintiff claims he was seized and arrested, regardless of when plaintiff claims that occurred, further supporting the Ironton defendants' argument they were not concerned with his speech or recording activities. Irrespective of plaintiff's First Amendment theory of recovery, he has failed to establish he's entitled to relief at every elemental level of the claim. The first one's strong. The subsequent ones aren't that great. Additionally, in an effort to attempt to bolster his claim, plaintiff in his new memorandum now implies an equal protection violation of selective enforcement. However, a cursory review of his amended complaint reveals that such a claim was never alleged and thus should not be considered in a response to a motion for judgment on the pleadings. I agree. But they're going to beat it anyway. They're going to beat it like a dead horse anyway. Notwithstanding the foregoing, plaintiff cannot establish a claim of selective enforcement. Every time I pick up my iced tea and I put it down, the dogs like have to check it out to see what's going on. Sorry. So that's what all the tramping back and forth is about. Notwithstanding the foregoing, plaintiff cannot establish a claim of selective enforcement. First, as noted by plaintiff, quote, the conscious exercise of some selectivity in enforcement is not in itself a violation of the United States Constitution. In fact, the Euler case goes further to state in that case that the petitioner did not state that the selection, quote, was deliberately based on an unjustifiable standard, such as race, religion, or other arbitrary classification. To successfully plead a selective enforcement claim, plaintiffs must satisfy the following three elements. First, a state actor must single out a person or persons belonging to an identifiable group, such as those of a particular race or religion, or a group exercising constitutional rights for prosecution, even though he has decided not to prosecute persons not belonging to that group in similar situations. Second, he must initiate the prosecution with a discriminatory purpose. Finally, the prosecution must have a discriminatory effect on the group which the defendant belongs to. Although plaintiff has failed to plead such a claim or facts in support of such a claim, it is important to note that while plaintiff was ultimately the only person arrested for criminal trespass when others were supposedly present, plaintiff is the only person seen or heard explicitly refusing the building staff's request to exit the building at 5 p.m. Plaintiff has not pled that similar to his actions, the, quote, approximately 14 other individuals, end quote, explicitly refused to leave the building when ordered to do so by the building staff and ignored the Ironton defendant's cease and desist order. Nor has he pled that he was singled out for a non-discriminatory purpose. Period. Wow. Accordingly, not only is he not sufficiently. Whoever wrote this was suffering from Kate disease, where they just like to throw extra verbiage in for no apparent reason. It makes it hard to read. If they took all of this out and said, plaintiff has not sufficiently pled a First Amendment retaliation claim and has also failed to properly plead a selective enforcement claim. D, plaintiff has failed to demonstrate that he's entitled to relief under the 14th Amendment. Plaintiff's 14th Amendment due process claims stem from his allegation that the Ironton defendants unlawfully withheld and damaged his iPhone. As an initial matter, plaintiff has failed to allege any facts indicating that his remedies under Ohio law are inadequate to redress this alleged wrong. The Sixth Circuit has specifically held that state remedies, such as the replevin proceeding under state law, are an adequate remedy for individuals seeking property that has been seized by police. Plaintiff did, in fact, file a replevin. Replevin just means giving my stuff back. And it's not necessarily just against the state. You could file a replevin action against an individual. It's just like, give me my stuff back. Normally, like if someone takes your stuff, you can either sue for the value of the stuff, or you could sue to get your stuff back, or a combination thereof. Like, give me my stuff back and the value, the lost value to me, or the reasonable rental value of it, or other such goodiness. So he did, in fact, file a replevin action against the Ironton Police Department in Ironton Municipal Court with the case number. The objective evidence remains that the court observed the defendant, Ironton Police Department Representative Pam Wagner, returned to the plaintiff, Jose DeCastro, the iPhone 12 Max, subject to the replevin action herein. Therefore, the plaintiff has obtained possession of the subject property and no evidence was presented as to any damages. Thus, the case herein is dismissed with prejudice. So he got back what he wanted. So it's res judicata. And I remember this. The problem here is that he didn't actually plead any facts as to the value of the damages. He didn't allege the damages. Like, he didn't say, like, it cost me this much money to repair it, and here's the receipt or something like that. Thus, plaintiff has not filed a replevin action, but said action provided him adequate procedural due process. Moreover, there is no indication that his phone was damaged at the time of replevin hearing. Accordingly, because plaintiff has failed to allege any facts indicating that his remedies under Ohio law failed to redress the wrong complained of and are inadequate, he has failed to state a due process claim that is actionable in a 1983 proceeding. E. Plaintiff has failed to support his claim for relief pursuant to Monell against the City of Ironton. As outlined in the Ironton defendant's motion for judgment on pleadings, a Monell claim cannot exist without an underlying constitutional violation, which they've just wrecked all of his underlying constitutional violations. Here, the Monell claim is based on targeting persons exercising their First Amendment rights, i.e., recording public officials in the City of Ironton and arrest them, unlawfully search, seize, and permanently damage recording devices to deter said protected activities. The Ironton defendants were not targeting persons practicing their First Amendment. Rather, the Ironton defendants lawfully arrested plaintiff who were criminally trespassing. Even though we are testing the sufficiency of plaintiff's amended complaint, his response still fails to adequately, or with any level of specificity, identify a policy or practice that caused the injuries complained of. Rather, plaintiff generally states that the practices of the City of Ironton led to his arrest without probable cause, and that the Ironton defendants promulgated the custom practice or policies which enables officers like the defendants to target proponents of First Amendment protected activities, i.e., recording public officials in the City of Ironton, and arrest them, unlawfully search, seize, and permanently damage recording devices to deter said protected activities. Plaintiff's Monell claim is highly illusory, and there is no discernible custom or practice contained therein. As applied here, there are only two routes for plaintiff to establish a Monell claim, i.e., the existence of an illegal official policy or legislative enactment, or the existence of a custom of tolerance or acquiescence of federal rights violations. With regard to an illegal policy or legislative enactive, plaintiff must, quote, identify the policy, connect the policy to the city itself, and show that the particular injury was incurred because of the execution of that policy. Furthermore, federal courts require a higher standard of pleadings. Threadbare recital of the elements of a cause of action supported by mere conclusory statements do not suffice. Twixby, Twombly, and Iqbal. Oh, here we go. We got Iqbal down here. I was waiting for that. Specifically, labels and labels and conclusions, or a formulaic recitation of the elements of a cause of action, provide insufficient grounds for entitlement to relief. What Twombly and Iqbal do is require that plaintiffs provide factual allegations from which a court might plausibly infer a cause of action. Simply put, plaintiff's amended complaint is devoid of and fails to identify with any specificity a legislative intent or policy of the Ironton defendants that would pass muster under Iqbal and Twombly. As such, plaintiff cannot satisfy this portion of a Monell claim as a matter of law. I agree. As to the latter, i.e., custom or tolerance or custom of tolerance or acquiescence, plaintiff has not, nor could he, identify any formal rules or understanding, written or unwritten, establishing fixed patterns of action to be followed under similar circumstances consistently and over time. He just said, it happened to me once, therefore it's a pattern. Ugh. Furthermore, plaintiff's amended complaint fails to identify any additional instances in which this seemingly unidentifiable custom resulted in the injury to proponents of the First Amendment due to the Ironton defendants. By implication, plaintiff attempts to establish a custom based solely on his own experience. The Sixth Circuit in Nori explicitly held that such an approach is not enough to state a claim. Similar to the first portion of the Monell analysis, plaintiff has failed to identify any custom or tolerance of the Ironton defendants that led to plaintiff's arrest, allegedly without probable cause. Assuming arguendo, that just means like for argument's sake. They're not saying, we're not saying this is true, but for argument's sake, let's just say for argument's sake, the plaintiff was arrested without probable cause. He still failed to sufficiently identify and connect a custom of tolerance or acquiescence of the Ironton defendants to his arrest. Consequently, plaintiff's Monell claim cannot survive the rigors of Iqbal and Twombly. Furthermore, as outlined above, there is no underlying constitutional violation, thus this claim must be dismissed. F. Plaintiff has failed to meet his burden, and the Ironton defendant's qualified immunity remains intact. The only determination left for this court is whether plaintiff has met his burden to establish the Ironton defendants are not entitled to qualified immunity. I fucking forgot about qualified immunity. All right. Well, hold on. We're going back up. That's what she said. No, I still think they fail on B. I don't know that it would be not established that you can't search a phone without a warrant. I don't know that I would bet that that's established, considering the prevalence of phones and the proclivities or the desire of the police to search phones. I would bet that someone somewhere in the Sixth Circuit has searched a phone without a warrant, and it made it to a court somewhere for a Fourth Amendment violation. So I would bet. Yeah. Okay. The determination of whether qualified immunity shields a defendant involves a two-part inquiry. The court must determine, one, whether the plaintiff suffered a violation of his constitutional right, and two, whether the constitutional right in question was clearly established constitutional right of which a reasonable person would know. Notwithstanding plaintiff's inability to support a 14th Amendment violation, plaintiffs, is there more than one plaintiff? Hold on a second. Is there more than one plaintiff? Nope, there's only one plaintiff. Plaintiff cannot point to a violation of a clearly established statutory or constitutional right of which a reasonable police officer violation of a clearly established statutory or constitutional rights of which a reasonable police officer have known. Okay. That's a fucked up sentence. In order for the violated right to be clearly established, the contours of the right must be sufficiently clear that a reasonable police officer would understand that what he or she is doing violates that right in light of pre-existing law. The unlawfulness of the official's action must be apparent. The right must be defined at the appropriate level of specificity to determine whether it was clearly established at the time the defendants acted. As an initial matter, plaintiff argues that an arrest without probable cause is a clearly established right. However, plaintiff's high level of abstraction does not satisfy the standards enumerated above, i.e. the clearly established right prong of the qualified immunity analysis. We have previously explained that the right allegedly violated must be established, not as a broad general proposition, but in a particularized sense, so that the contours of the right are clear to a reasonable official. Furthermore, the Supreme Court has held that it is not clearly established that an arrest supported by probable cause would give rise to a First Amendment violation. That was Reich versus Howard in 2012. Interesting. I don't recall that case. I might want to read up on that. In assessing the, quote, clearly established, end quote, standard regarding the arrest pursuant to probable cause, the Supreme Court held that the clearly established standard is not satisfied here. This court has never recognized a First Amendment right to be free from retaliatory arrest that is supported by probable cause. Thus, plaintiff's failure to overcome the Ironton defendant's entitlement to qualified immunity is twofold. More specifically, generally alleging an arrest without probable cause is not sufficient to establish a, quote, clearly established, end quote, for purposes of qualified immunity. More specifically, generally alleging arrest without probable cause is not sufficient to establish a clearly established for purposes of qualified immunity. That is another fucked up sentence. I don't know what that means. And who starts a sentence with and? And if he did, the probable cause previously established by the Ironton defendants vitiates and overcomes plaintiff's argument that he was arrested without probable cause. Consequently, the Ironton defendants are entitled to immunity, and this action must be dismissed. Based on the foregoing, yada, yada, grant it, yakety, schmackety, blah, blah, blah. Okay, here we go. All right, it is time for me to ritualistically humiliate myself and you. We'll go big or go home. What do you say about that? Go big or go home. Oh boy, Freebird. I don't know Freebird, so you're going to have to give me a pass on that one. Merb will be on as soon as he loses his pants. I did not come on until I was buck naked below the waist. This is one of those pre-recorded videos that he doesn't even feature a musical interlude. I'm out. Peace. He was amped. My zipper was stuck low. It's Friday, the only day of the week Merb wears panda. I never wear panda. They're an endangered species, and people don't really like it when you wear panda. Lol, what the hell? Unstuck it. Come on. Pants. Oh my God, Merb is going live. Oh my God, it's a boomer. Hello. Oh my God. I demand a refund of my admission ticket. Well, as it so happens, I will refund you every penny you paid to watch this. Hurry up with that zipper, Merb. Pantsless is best. Why don't you help me out with it next time? Oh my God, oh my God, oh my God. I'm giddy. Wow. Clearly, he's watching the end of WNN's riveting live. I wasn't. You think Merb will notice me? Face blue smiling. Apparently I did. Boomer, great enthusiasm displayed. Yo, wow. High hands. Merb does tech. Not well. You know it. Hey, everyone. CFW. Carolina, Fort Worth. Yes. Carolina, Fort Worth. Yes. Selfies in YouTube made stupid yet desperate for attention criminals easy to catch. Surprisingly, it did. One would suspect someone would never record themselves committing a crime, and yet they do. Do you think Fat Hemming would go up on panel and compare pube beards with Merb? I'm sure he has a luxurious beard, and I'm sure that my beard pales in comparison. Oh, you're real. A real silly goose. Thanks, Boomer. Yeah, but Chili's not a bright person. Nailed it. Yes, you are real, Merb. Looks real to me. Did you guys see my dick or something? Did you tick off the tech gods? I probably did. Merb, did your pantsless bottom give your desktop a virus? I always wear a condom. Even right now. Tell us a story? No. Kick it. That usually works for me. Yes, he did, orange cones. Carolina, Fort Worth. Merb is not real. He is a figment of your imagination. Probably true. Throw your computer in a fish tank. No. Tell us how much you love my cat video. I was told that you had a great video of that really shitty Mark Stout rap that's done to barbecue, and I need to watch that. But no one has forwarded me a link to it, so I have not yet watched it. But I hear it's awesome. I hear it's better than the original, which really doesn't mean much because the original really sucked. Try hitting with a hammer. Looks like Merb froze up on us. Tech went screwy because you're wearing pants. I wasn't. Fragment. Fish. Fishy. Emergency maneuver 13 and technology don't mix. Merb is muted. Even your computer has had enough of chili. Oh, face palms. It's his lack of pants that did it. It is never my lack of pants that does it, sir. Merb being frozen made me want to ride his pubic beard face. How weird. That is a little weird, but not uncommon. Chili must have taken him out. Looks like the computer says no. I see and hear you. This is totally whack. It is. Does anyone know what he's referring to? I don't. Who turned off the lights? By the way, Boomer, I love how you said puby. Computering is hard. It is hard. Yep, pants. Lol, Wagner, keep your hands to yourself. No. Merb's best stream ever. Yes. Yay! He's doing a reboot. I was. Okay then. Welcome back. Back, still no toothbrush and still puby face, but I'm ready for it. Let me clean a spot off here for you. Frozen now? What were you doing with the light off, huh, Merb? You'd have to take me to dinner to find out. I'm only a bit late. Hello and good evening. Hemming's pube beard has taken control. It must be the power of the fish and no pants. You triggered those guys last night. I did. Pants. Merb's purring sends shivers down my spine. Damn, you're sexy, Merby. Merb is dead. Long love, Merb. You are fine. Volume's fine. Audio fine. I am fine. Shouldn't have fired your producer. Well, I just fired him again, god damn it, because he's a real piece of shit. Irish Demon can help. Pants off, dance off. Every time, all the time. You didn't read my comment yesterday. Can you insult me tonight? You're not worth it. Well, hello. How's the date going? Irish Demon can help again, okay? We louve Merb at Robert Stout. Or Robert Scott. Yes, we do louve me. Why don't the defendants motion for an in-person hearing and force him to show up or dismiss it? Just motion for an in-person hearing like, Your Honor, I'd like to file a motion to make Chili come out here. That's it. That's all we want to do. Your adorable Indiana observer. Adorable. Back, front. Everyone loves Merb. I don't think everyone. I would suggest to you, on information and belief, that Felipe does not much care for me. Oh, Lord, no. Back again. Can you get Chili up to give us his thoughts on the motion? I don't know. If Chili shows up, I'd probably let him on. I don't really care. Disingenuous and self-serving. Go Pam. Oh boy, more Chili. Want to get baked and talked about the A-team? Absolutely. Except I don't smoke the marijuanas because they lead to reefer madness. Hello, Madison Lee. Hello, Max. Dog Detective is better looking than Merb. Probably. I am sadly not on a date. Well, go back to your corner. Maybe you'll make an extra 20 tonight. Yes, Merb is a great aphrodisiac. You're weirding me out. Ha ha, Madison on a date? Allegedly. Has anyone notified Pants Merb is streaming? He wanted to make sure someone told him. Lights off, pants on, pants off. Sure. This date was going so well, and then someone told me it was sewn shut. You were the date, huh? Huh, WTT? Nice. Absolutely, Paul Berry. I loves me some horny anime girls. Horns on the head is sexy. You want to impress a date? Turn on some Merb. Works every time. Every time, all the time. It's a weekend date. We need some time off. Lol. Right. Yes, Bits. It would impress me on a date, but I'm cheap. My favorite. Chili is the definition of spoiled. Sewn shut. Just ask Felipe. Sweet. Maybe Pants can opine on the word faggot with Merb. 60K subs less than Chili, yet nearly the same amount of people on your live streams. My go-to pickup line, want to come over and watch some Merb? Works every damn time. You know it, Jose. I think Merb should grow a mullet, non-ironically. I like what you're thinking. Yep. Oh my god, Boomer. Mullet Merb sounds marvelous. It does. Chili is such an idiot. He is. Oh, just no, Boomer. You look cooler blasting woodpeckers out of the sky if you rock a sweet mole. Tennessee top hat. A mullet on Merb with that beard would definitely start a trend. Definitely. Joe Dirte, my little Joe Dirte mullet. Chili bought and paid for his subs, just saying. And far less wrenches. I should not have any wrenches. If you see a wrench, let me know, because it would have been like me fat fingering something. And not in the good way. Boomer. What was the name of David Spade's mullet character? Joe Dirt. I'm having a brain fart, but Def would shoot woodpeckers. I got a woodpecker for you. The wedgie you caused Felipe Hemming was jammed so deep his doctor needed a long reach backhoe for safe extraction. That was a long story, but it was worth getting there at the end. Technically, his subs bought Chili more subs. Merb Dirt. Joe Dirt. It's a space peanut. Mullet Merb Dirt. I think we got a winner chicken dinner. Pam Wagner is now retired. I feel like Merb rocked a mullet when he was younger. What is Chili up to? I quit watching any of his videos, even from other channels, and yet you ask what he's up to. I pity the fool with the mullet. If Pam Wagner's last official act is getting Chili's LOL suit dismissed, I'd say she earned her retirement with pay. I wonder, did a young Merb ever have a rat tail? Liar McLiar Pants. He is up to the same old shit, suing people and filing cases and grifting. Chili is about a 50 IQ. I think you're being generous. LMAO, good evening all. Just checking in. Is he wearing pants today? Merb claims he did manual labor once on the docks or some shit. But deaf rat tail. Never had a rat tail, sorry. Does he ever? If there was a negative IQ spectrum, Chili would be on it. He's on a spectrum, all right. Maybe I'll start growing a mullet to show Merb there's nothing to be afraid of. I'd like to see pictures of it. Good evening, Tracy. Merb, the lawyers for Wagner, etc., are located in my city. They are very good lawyers, and Chili can't beat them. Okay. Tell them to spell check. You are not a true Merb supporter unless you grow a mullet. The question is, do we grow the mullet on our heads? Or ... Did you hear that? He said oopsie doodles. I say that all the time. It's Merb's way of saying hi to me. We are the same now. I think he was wearing pants, which caused the tech problems. LMPO, laughing my pants off. Liar, liar, no pants on fire, because real Merb fans do not wear pants. Scam artist. I think Chili's problem started as a little kid when his family left him at the Grand Canyon, but he found his way home the next day and they tried again. Some skull going on there. That's actually a good point you bring up. We're not going to be mullet bros and watch A-Team together and hotbox, or we're going to be mullet bros and watch A-Team together and hotbox our living room tent. Doesn't sound like a bad time. Liar McLiar Pants who lies. Oh no, he didn't. No statute exists to support his claim. Hilarious. Don't make fun of Ohio lawyers, Merb. They try hard. They did try hard. Chili's on the run. If you don't have pants, you can't be a liar, which is why I don't wear pants. He said, I believe he wanted to get arrested in his video. Joe Dirt. Hey, Pants. Merb has a mullet? Sorry, Merb. Sometimes pants lie. They do. Thanks, Leanne. Hey there, Pants. Sup? Pants, good to see you survived. It was tough to hear you munched your limbs last night. Merb, why does Felipe hate me? Well, you see. Once upon a time, Felipe was the attorney for the First Amendment movement. People would say, when they were about to get arrested, they'd be like, I'm going to call my attorney. Hey, Felipe. And then I made a few little videos suggesting that maybe, just maybe, Felipe wasn't an attorney. Oopsie doodles. Boomer, at least it's a living room tent and not an outdoor tent like Stout Pro Se Litigation, LLC. I thought his tent was in his mom's garage. Maybe I was misinformed. You're welcome, Laura. Merb's pants is in the house. Hey, Shiz. It's got to be a lover's quarrel. Nah, me and my new brother Merb are no scrubs. Our living room tent will be dope. Rope lights and everything. Rope lights? Fucking shit. Can we get a live, laugh, love sign up in this bitch too? Felipe wants the Merbs for bad. He does. Once I came out of the closet as gay boy, he was all up in that. He's like, so you like to kiss boys? Are you top or bottom? You like bears? You like bears? Hey, all you followers of this beard per Felipe. So many activities. Merb did a video on Felipe about 3 years ago. It's still up. I did several videos on him, and they're all still up. Boomer, please promise it's not a no girls club. I love hotboxing in living room tents with dope rope lights. It's the boy hating women, or the no women boys club. It's the women haters club. Yeah. Bros only. Bros before hoes. Awesome. Nighttime story time. Never mind, it's just another docket. What do you mean, just another docket? The law is sexy, my man. Sexy. Sexy. It's the law. And the unbrushed teeth, they were born this color. My mom has them this color. My dad has them this color. Like, I don't whiten my teeth. Sorry. Sorry, not sorry. Aw, heck no. You can come chill with us. What do you think about watching Macho Man Randy Savage highlight tapes? Randy Savage? Yeah. Me and Elizabeth. How would Felipe feel? Or how would Felipe know Merb's oral hygiene routine if they hadn't been romantically involved? Well, he wants to kiss me, and he just wants to make sure that my breath is really fresh. He wants my breath to be so minty fresh when he kisses me. Boomer's cheating on you? I'm sorry, Kate. His penis can't get past lips. With Merb again. Swiggity swaggity, I'm coming for that booty. Or swiggity swooty, I'm coming for that booty. Do not threaten me with a good time, sir. Sir. Fucking Boomer. You wish you were. He's hot. Oh my god, oh my god, oh my god. Good point, Pants. No, I'm not. I'm throwing Henny bottles at the wall and cutting my bangs with kitchen scissors. You don't drink Henny. That's too expensive. No retaliation, just a spanking. A spanking! Everybody likes a good spanking. Felipe has such a hard-on for Merb. He wants to kiss Merb's supposedly dirty mouth. Keeps telling Merb to brush his teeth. He wants to kiss more than just my mouth. Kate, that's hot. Hey, Kate. Ooh, since he's going to be reading these, I should write a heartfelt apology to him. I should write a heartfelt apology for him to read us for being such a jerk earlier today. You were a jerk, and you still are, so. Shiz. Heart it is. Ooh, let me do your hair. Oh my god. Merb has a prettier mouth than me. Damn, Grizzly Adams mix in some just for men. Better to ask for forgiveness and for permission. I crave love, and Merb was giving me signals. I'm sorry. I'm just so dang weak. Hey, Kate, was Merb correct that you assaulted and battered Chili with your tits? She did. How can you tell with a pube beard? That's a good question. Do it, Pants. It'll be good. I am sure. He certainly has a better beard. I crave love too. Boom. It'll be okay. What is love? Baby, don't hurt me. Pube beards are what all the hipsters are doing. Yeah, it is the rage. I mean, no hair down there, all the hair up here. Good times. I need to know why you broke Felipe's heart, Merb. I just explained it. He's not. I like otters, not bears. Okay, otters. He said he would get us mullets and a living room tent and everything, and we could smoke weed and watch the A-Team. Did they do this to force Chili back to Ohio? No, he doesn't have to go back to Ohio for this. He could, if there is a hearing on it, he could just appear remotely. I prefer not to floss while I dine. Just saying. Well, you don't want to floss while you dine? Goat turquoise white horns. Yeah, I inherited your beef with Philip. I don't know who Philip is, but okay. He probably hates me too. No one hates you, Shiz. Hey guys, I need a car at Beach House. If you guys can help me with that, it'd be great. Oh, by the way, I've already submitted the paperwork for a 501c3. So donate now, and then maybe you'll be able to write it off at the end of the year. I thought this case was dismissed because he failed to follow up motion. No, he filed a motion for leave to file late. Does the car have to have AC? No, he said that they could put it in. Doesn't Chili have an active warrant in Ohio? I believe he does. Oh, that would be hilarious. If this went to trial and they required him to show up, it's never going to get to trial. The car does not have to have AC, but the beach house does. Yeah, I mean, obviously you'd want a beach house with AC. I think he has 2 outstanding warrants in Ohio. 2 active warrant. We can go have halfies on it if you're being a beta about it. Shiz, did you end up watching The Mud Wizard? Gonna be another L for DeCastro. Alphas don't say words like halfies. Why the hell is he fighting a case in a state he has an active warrant? He does know what happens when he shows up for trial. That's tomorrow. That's tomorrow. There's a level of intelligence required before you can really think about the future. You know, there's some people who are just so stupid they live in the right now. Like they don't think about the consequences. They can't think about the consequences. They can't think about what led them to where they're at. It's just right now. Whatever is right now, that's it. I mean, they can remember the past, but they can't formulate plans like this happened when I did it last time. So if I do the same thing, the thing's going to happen again. They can't do it. Alphas have typos. Alphabets do too. Ha ha ha. I haven't watched it yet. I forgot I'll watch it now. I pinky swear I'm alpha. We'll have to set up a cage match to find out. Yo. You're alleging that Chili knows something. Citation needed. That's an excellent point. I am so in. In what? I wonder if Merb has an original Atari with a wood panel. No, my dad, I remember we went to the airport. And we bought an Atari out of the back of a guy's trunk, but it was the Atari 800, I think it was. It had a keyboard on it, and it didn't take the game cartridges. It took smaller cartridges, and we got a floppy drive for it. It was badass. And yeah, we literally went to the airport and bought it out of the back of a guy's trunk. My dad did some shady shit, apparently, that I didn't realize was shady at the time. Okay, I'm out. Peace. I hurt my butt doing stuff. Amateur. Another good point, Pants. Rolling with some guys. He unplugged the vacuum of the janitor. He was probably screaming his ass off and swearing and calling people bad shit. But she also said vacate or you will be arrested. Yeah, okay. Okay, I remember that. So that might have been the disorderly conduct. Yeah, that I didn't remember. He interfered with the janitor doing his job. He unplugged his vacuum and yelled at him and threatened him. Okay, that makes sense. That's I remember that now. That was a disorderly conduct I couldn't remember. He was loud, plus he was trying to say he had a right to be there. Well, not necessarily disorderly conduct. Yeah, but the disorderly conduct comments by Pam was stupid. Okay, on video. Okay, Merb is thirsty tonight. No, I've got delicious iced tea. He had restraining orders that prevented him from being near the police officers. He then went to a seized car auction and the officer showed up. He had to leave. I don't know what's about. Nuts. I'm really late. Someone needs to step forward and accept responsibility for this outrage. I am so sorry. It's my fault. I don't give you guys a lot of heads up on these. So that's my bad. Wasn't the janitor thing disorderly conduct? Yes, probably. All Pam had to say was, leave now or you'll be arrested for trespass. I don't know why she had to say that other crap. Because people tend to react in situations, and she was probably throwing out like the first thing she thought of. She probably got called there based on the disorderly conduct. And then also, by the way, it's closed. She probably hadn't even put together it was closed or something. I'm not even sure. But she's probably just reacting. Show us the dog. Is that what you call my penis? Hey. Shout out to the creative writers. Stay out of pleadings. Got to remember it's Ohio. I know. Chili was the only Alaskan. Not sure if they used the video Chili Beans took of his arrest, but initially he clearly tells the cops, I'd love to see the inside of your dungeon. Well, that doesn't mean they get to arrest him. He says a lot of stupid shit, but just because you say stupid shit doesn't mean that they can arrest you for it. No worries, Kate. Extra verbiage, like extra cleavage, can be very sexy. Not in pleadings. You don't want tits or extra verbiage in your pleadings. In all fairness, his iPhone was the most expensive item he owns. He was probably giving it. Probably Jose. Hello, Shiz and Troll Mafia official. His glasses are the second most. No, they're just like the cheap reading glasses, men or women's cheap reading glasses. Red ones, lol. Yeah, red ones were almost $20. That's a lot. That's a lot of e-begging. Ha ha. I'll be back. Dude, where's my free car? Merb. People often get paid by the number of words in these submissions. I'm not aware of any of that. I don't know why any attorney would get paid by the word. That's stupid because you could write a lot of words. I mean, like I could pound out pages and pages and pages of typing in a day. Burb gets more views than Chili now. Is that car Chili's been driving around in his new home? Or is he borrowing that one too? I'm probably borrowing it. The 15-second short I just posted of my dog chasing my cat around got more views than Chili. To be honest, I'd rather watch a dog chase a cat than Chili. Lol. Chili doesn't own a car? Probably not. I bet Chili's a loner dog. Oh, leave Charlie alone. Charlie is a good dog. Charlie's not a beta dog. He's a good dog. He almost 50 gave him time. One day he just might supervise everyone and own a car. I doubt it, but there's a chance. A reasonable person, obviously they're not talking about Chili. Surprise, clearly. Are we taking bets on how quickly Chili gets that free car with air conditioning donated to his new charity, paperwork coming in a few months? I mean, there's a lot of stupid people out there. I mean, Chili has a sugar daddy or two. I mean, if he gets a car, it will be repossessed, so it won't last long. Now, the funny thing is he never had to beg for a car before. Now he does. So that makes you wonder, doesn't it? Maybe that tap is drying up. Maybe Chili's getting a little too old. He's not tickling their beans anymore. You know what I'm saying? I mean, if he gets a car, it will be repossessed, so it won't last long. Could be. Yo, no one told me there was going to be a reading required. Sorry. When I first saw Chili's short begging for someone to donate a car to him, I seriously thought it was a fake Chili doing a parody. I know. Brace yourself, boys and girls. Are you about to do something sexy to them? I like the beard no matter what Felipe says. I'd like it pressed up against my... Never mind that. Well, you know what? You buy me dinner and we can work something out. We all need some yakety smackety. I thought you were not watching again. I wonder if ChatGPT has a Chili translation capability. Put your pants on, Merb 34th Street. No one put their pants on me. I don't want their pants on me. Felipe will be watching this beard closely. He will. He probably wants a car clips because Chili can't register the vehicle he's in now. He did say the tags were expired. I'm just here to see you, GD. It's love. Love's in the air. A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, Q, R, S, T, V, W, X, Y, and Z. Now I know my ABCs. Next time, won't you sing with me? Pants, I'm not into baddie bixes. Whatever. Where are the moderators to protect me from all the bad people? They're in a different chat. Boys. GD likes boys. Chili's a wanker. Chili's a wanker. He is. Haha. Mark Stout is an accomplished MC. How dare you? Well, maybe I'm just not a sophisticated connoisseur of music. Oh, I wish I were an Oscar Mayer wiener. That is what I truly like to be. Because if I were an Oscar Mayer wiener, everyone would be in love with me. What's up, Playboy? Wignette Stopsky. I'm sorry that I hurt you. Kate played Stout's fat beat last night on her stream. It's okay, Boomer. Just grab the nipple clamps and we'll work this out. But who is going to get the nipple clamps put on them? Inquiring minds want to know. As Felipe went into hiding, he did not show his face in my Discord all day today. That's kind of weird. Normally he's in there just like arguing matches with people. I never see when Merb starts streaming. Looks like I'm the other end. Are you the caboose? I think Hemming wants to fuck Merb. I believe you're correct. That's what she said. I said, hey, what's going on? And I said, hey, yay, yay, yay. Chili bait is BOGO. Buy one, get one free all weekend. Nice. Chili wants Merb's fudge pop. He does. Where are you seeing all these messages, lol? The sexual tension between Merb and Felipe was uncomfortable. I wasn't uncomfortable. I must be late. Sorry. Yes, Harry. Before I go watch this from the start, did you explain what bug it was to you? What bug it was you put up Felipe's ass? He really didn't seem to care for you, but I couldn't infer a reason from his kinder insult. Um, I explained it a little earlier, but what I said, I don't believe I insulted him on Kate's stream. I just explained why what was going on there wasn't what people expected or wanted, or it didn't really address any of the questions that were raised. Hi, Nima. Chili is at the gay gym taking his shirt off for men in the bathroom. It's interesting that you know that. Did Chili damage his case more last night? He didn't help it. He didn't hurt it. Oh, yeah, I forgot. Merb kills woodpeckers. I will neither confirm nor deny. How's the weather outside? It's dark. It was a very nice day today. Thank you. Save the woodpeckers. You go ahead. You foster them all in your place. I mean, you're not wrong. I've got coveralls on right now, but no pants underneath. Can Merb file a replevant action against whoever stole his pants? No one stole my pants. He acts like him and his wife are an attorney team, but really his wife is the one of them who's a real attorney. Yeah, Felipe was her secretary for quite a long time. He-Man Woman Haters Club. That's it. That's what I was looking for. Yeah, dog. The He-Man Woman Haters Club. Yeah, buddy. Merb, you old fuck. Yes, I'm an old fuck. I'm assaulting Boomer with my pubes right now. Oh, lucky bastard. Both of you are lucky, actually. I'm late. I know that upsets Murbies terribly, very much. I was actually uncomfortable continuing the stream without you being here, and I was seriously considering just waiting for you to show up. But but I'm glad you're here. It's better late than never. How can Chili win a civil action when his criminal action is still in limbo? Well, is that the younger abstention doctrine? There's a doctrine, I forget which one it is. I think it's the younger abstention doctrine that basically says that you can't sue over like a false arrest or something like that, or a wrongful arrest when the criminal trial is still going on. So I think that would eventually apply, like to prevent it from proceeding. But I'm a little unclear about that. Cholito has now asked for another donated car for his new 503C, to which I respond, what 503C? It doesn't exist yet. There's no guarantee it will exist. You're expecting Chili to be able to properly file paperwork to accomplish something. I'm going to go with I doubt it, seriously. And there's a lot more to it. I mean, there's things he has to do at the state level too, like to set up a business. I mean, I just don't think it's going to be happening. Show us your tits. I've seen that you have quite a pair. You show me yours, I'll show you mine. And by the way, quit flirting with Felipe, okay? He's mine. I get to rent the U-Haul. I can't wait for Chili to be in front of Judge Ford. I'm giddy with anticipation. Probably will never get there. Optimal tip-to-tip efficiently. Start from the middle, apparently. I watched a video on it. It was weird. It was weird that YouTube has a video on how to jerk off as many men quickly as possible, where they have like you start off and then there's a tip-to-tip ratio for height, and you start in the middle and you could switch people up mid-stroke. It's kind of weird. Is this thing on? No, you're not turning me on. Tits and extra verbiage is literally all there is to me. No lie detected. A pleating is like a skirt. Too short is slutty. Too long is boring. No, concise is the name of the game. Madison, did you get a peek at Merb's wee penis? Restraining orders in Ironton after arrest. That's why he's claiming First Amendment restrictions after arrest. Well, he needed to specify that clearly. Lol, no. I was having a run of eye bleach. I have run out of eye bleach. Dragon Legal have it set on genius mode. Okay. Ha! I like that. Good dog woke up Merb's dogs. Is receiving stolen property from the back of a guy's van illegal? It depends. Sugar daddies prefer boy toys, and half a century old is no longer a boy. That's what I'm saying. Like his expiration date is coming. Chili can't deep throat like you used to, or chill can't deep throat like you used to. Just that you know it speaks more about you than anybody else. Why doesn't Chili just drive to go get DLZ clips? Is that who he's wanting to get the car for? Probably because I don't know. I don't know. Silly Sally swiftly shooed 7 silly sheep. The 7 silly sheep, silly Sally shooed, shilly shallied south. These sheep shouldn't sleep in a shack. Sheep should sleep in a shed. When did Child beg for a car? It's a short that he put out today. That was deeply disappointing. If it was deeply, you wouldn't be disappointed, pants. Don't lie. I hope when your moves up and down, you are just scratching. Oh, sure, I was just scratching. Oh my gosh, I didn't get a notification. For the record, it's a very nice beard. You just want to sit on it. They did take up for your beard, just saying. I know, I was laughing my ass off. It was fucking hilarious. I'm on drugs. No, I refuse to believe that, boomer. You are as untainted as the first snow of winter. Your teeth look great. Felipe, my teeth don't look great. They're natural. I brushed them, but they're a yellowish gray. I mean, it's just the way my teeth are. Felipe and I are in love. I know. You're willing to rent a U-Haul that's big enough to haul him around? Just remember, it's illegal to poach whales. It's understandable. I know. He's a good-looking man with I hear a very beautiful beard. Everyone could see our chemistry. Thanks for watching. Have a great day. I'm shopping True Yorker in Felipe's wedding registry right now. I didn't know they needed so many. I don't know why they need so many plastic mattress covers, but okay. I could hazard guesses, and that's one of them. Oh goddamn! When is Chili coming over to get plugged by the goats? You can calm him down. It would be nice if you can calm him down. It would be nice, as I like to watch. Let's go, sports team. Merb, quit pulling on your tiny pecker. No. Thanks for watching. Have a great day.